The information contained in this video is intended as a general overview of common issues in divorce regarding property and debts. It is not intended to be relied upon as legal advice. For legal advice, you should consult an attorney. When you get divorced or legally separated, the court will make a decision about how to divide the property that you and your spouse acquired during the marriage. The court will also confirm separate property to the parties. Property is anything that can be bought or sold and can include a house, furniture, and cars. Property is also anything that has value, such as cash, bank accounts, retirement accounts, pension plans, or a business. California is a community property state. This means that two married people are the same as one legally financial community. Property and debt that a couple acquires during a marriage is community property. Community property is everything that either one or both spouses acquired from the date of marriage to the date of separation that was not acquired by gift or inheritance. This includes all the earnings that both spouses earned during the marriage and everything purchased with those earnings. Community property also includes financial obligations accumulated during the marriage, even if the debt is only in one of the spouse's names or incurred by only one spouse. Quasi-community property is any property that was acquired by either one or both spouses when living in another state that had it been acquired while living in California, it would have been considered community property. In California, each spouse owns one half of the community property, and each spouse is responsible for one half of the community debt. Separate property is anything you have that you owned before you were married. Gifts or inheritance received during the time of marriage is also considered separate property. Any property purchased with money earned prior to marriage or after the date of separation may also be considered separate property. Debt, such as credit cards and loans, accumulated before marriage and after separation are also considered separate property. The law requires that in all divorce, legal separation, and nullity cases, each of the parties give a full financial disclosure to their spouse. This means that you must provide information about your income, assets, debts, and investments since the date of separation. Even if you do not have any property or debt, you must make a full disclosure to the other party. The divorce, legal separation, or nullity case cannot be finalized until the disclosure is completed. For many people, the retirement account is the most valuable asset that they own. Be sure that you know the details about retirement accounts and pension plans for yourself and for your spouse. You will want to collect account numbers and employer information. Contact the administrator of the retirement account to find out their specific requirements relating to the termination of marriage. If the employed spouse retires, dies, or remarries, the right of the former spouse may be affected. You can notify the administrator by sending a written notice that you are claiming an interest in the account. Follow up with the administrator to determine whether you need to provide more formal notice or a preliminary order to the administrator. Property division can be very challenging, especially with retirement accounts. In some cases, you may need to make the retirement plan a party to your case. The purpose of joining the retirement plan to your case is so that the court can make an order directing the payment of future plan benefits. Be aware of potential income tax consequences that result from the division of property. You may be liable for such things as capital gains tax, income tax, and property tax. It is highly recommended that you consult an attorney to discuss the possible risks and benefits. To find an attorney who specializes in retirement accounts and divorce, you may contact the San Bernardino County Lawyer Referral Service or the Western San Bernardino County Bar Association. When divorcing or legally separating, your property and debts will need to be divided. A good way to start is to make a list of everything that you owned. You will then need to determine which items are separate property and which items are community property. You also need to determine the fair market value of each item. You will also need identifying information such as the full legal description of any real estate, license numbers and vehicles, and account numbers for bank accounts. Community property and debt are divided equally by the court unless you and the other party agree to divide the property in some other way. Voluntary mediation can help resolve disagreement about the division of property and debt. The court can refer you and your spouse to a voluntary mediation settlement conference that may help you to work out a fair way to divide the property and debts. If you and your spouse are not able to resolve some or all of the disagreements on the division of property and debt, then the court will schedule a court trial. All of the necessary forms for the procedures described in this video can be obtained from the Self-Help Resource Center website, purchased from the clerk's office at your local courthouse, or by emailing your Self-Help Resource Center at selfhelpforms@sb-court.org. If you would like more detailed information regarding the topics discussed in this video, or if you have questions regarding your specific situation, please visit our Resource Center office in the San Bernardino Historic or Victorville courthouses.